Mr. President, I know Ms. Banafitemi is sitting down, but there were two questions that I wanted to very briefly answer that I didn't fully answer earlier, if it's possible. Okay. Mr. President, there were two questions that I wanted to come back on, one from Dr. Ponce and one from Professor Periscano, if I may. See, there's technical difficulties. I'll just give them a moment. No problem.
Put the contract on the screen. Yeah. The contract, not the contract. It's page 3.
Shall I proceed or shall we wait?
No, please proceed now.
Okay, thank you. But what he did mention is that the only requests that were ever made to La Palma around the same time as this, after the asset seizure, were pursuant to the promise of purchase agreement, specifically clause 3, which says it agrees to transfer title to the real property covered by this contract, free of mortgages, civil claims, seizures, conditions subsequent, pending lawsuits, ground rent, any encumbrance or limitation of ownership, and it shall defend title in those cases where it is required under the law. And there are two letters in the record at C419, and I have copies if the tribunal would find it helpful, and C418. C418 is November 23rd, 2016, and C419 is March 6, 2017. And that second letter actually quotes the provision I just read, where Mr. Seda is writing to Fanny Giraldo at La Palma, asking them to cover the fees to defend the title in actions, and I can provide these if the tribunal would want copies of each.
If they're on the record, that's fine.
They are on the record, yes, C418 and C419.
C418 and 19, huh?
C418 and C419. So to the extent there are any requests being made to defend title, you can see the formal letters where from Mr. Seda to Fanny Giraldo at La Palma. But obviously, for the avoidance of any doubt, the second point was Professor Periscano, in response to your question about the scope of the essential security exception and whether it covers breaches or just precludes this tribunal from saying the measure cannot be withdrawn. We do address this in some detail in our submissions, but there was one specific treaty that I wanted to bring to your attention, which is at CL 210. And it's the India-Singapore Investment Treaty. And that provision is different from ours in an important way. It's basically phrased like a denial of benefits clause. It says nothing in this chapter shall be construed to require a party to accord the benefits of this chapter to an investor that is an enterprise of the other party, where a party adopts or maintains measures in any legislation or regulations which it considers necessary for the protection of its essential security interests with respect to a non-party ... But that one clearly says that nothing in this chapter shall be construed to require a party to accord the benefits of this chapter in that circumstance. And this tribunal will be well familiar with denial of benefits clauses, where that's where they're saying, you don't get the protection of the treaty, you don't get access to arbitration, you don't get protection of the treaty. What I think is important is our treaty, the one that's at issue here, also has denial of benefits provisions. It has denial of benefits provisions. at 10.12. And it specifically says, a party may deny the benefits of this chapter to an investor of another party that is in an enterprise of such other party where they don't maintain diplomatic relations, or adopts, maintains measures with respect to the non-party or a person of that non-party that prohibits transactions with the enterprise that would be violated or circumvented if the benefits of this chapter were accorded to the enterprise or to its investments. So for example, maybe if one was on an OFAC list or something like that, then there's a denial of benefits. So they did deny benefits of the protections of the treaty in certain limited circumstances, but not in the circumstances at issue in this case.
Okay.
Those were the 2 points I wanted to address.
We would now give the floor to the respondent.
Thank you very much, Mr. President. One housekeeping matter is that we are going to distribute some slides. Is it coming or?
We already have them in the...
It was sent by email, apparently. Okay, so you have received them by email, and one of my colleagues will bring paper copies just in a few minutes for your convenience. Another housekeeping matter is that simply a number of comments made by my colleague and friend on the other side related to the treaty in response to the tribunal. So I will try to fit everything in the time that I have, but I don't rule out that I may need a bit more time because these are tribunal questions, if you allow me. So if the tribunal has just a bit of indulgence on the 49 minutes, because we do have a lot to say.
Yes, we will have some indulgence, but please do not go much longer.
I do not intend to abuse the tribunal's indulgence, absolutely. Indulge or overindulge. Thank you. So without further ado, I will start, and I will go through Mr. Moulou's presentation point by point. So this being a rebuttal, I would follow the same sequence. And for some of my comments, I will refer back to what my partner, Ms. Herrera, will say, because sometimes these concern the asset for future proceedings, and she will address those more in depth. In fact, the slides would have been helpful now because, yes, you can see them on screen, so that's perfect. So the first point made by Mr. Moulou was that the narrative by Colombia is that we are essentially saying do not invest in Medellin because it's a very dangerous region. That's not the point with respect. The point is that when you do attempt to invest in a region which is plagued by violence and by organized crime, the least you should do is that you should engage in due diligence and to know where you're going, essentially. So it doesn't mean that you cannot, but you know where you're going and you know where you're putting your steps. On the exact due diligence, and my colleague is now distributing the paper copies, on the due diligence itself, Ms. Herrera will go through that, but I wanted to just give you a sense of what the least you should do is to do a due diligence properly, and Ms. Herrera will come back to the due diligence that actually was done by Mr. Seda. But what you see here, and that's slide 6, is an excerpt of my cross-examination of Mr. Seda, and you see what he said. He said that, when I asked him about this, and I asked him about the danger in the region, he said it's a strategy. It doesn't always have to be danger. It could be other variables, etc. There's some unattractive, you see promise, you see that there's something that can be made out of it. You're a first arrival. You come in and you create attractive developments, and usually other people follow. It was our strategy. If it's a strategy, he has to live by the strategy and by what he did. So the next slides are the actual due diligence, which I will not go to right now. Ms. Herrera will actually develop this further. So I want to just stop here on the point, which is our narrative. Our narrative is if you go to a very dangerous region plagued by organized crime and the cartel of Medellin, you know what you're doing. It's your duty to engage in that. On the point, I think that there was a point made by, again, the dangerous region. So this has been accepted by Ms. Seda. The additional point I wanted to make is about the preamble. There was a point made about the preamble. It cannot be said in this tribunal. I would be very surprised that this tribunal says, given the preamble that we have, that it says that one of the purposes of the treaty is to allow narco-trafficking and corruption. It says the exact contrary. It says prevent and combat corruption. So that is the preamble, and that is the intention of the parties by entering into this treaty. It's not the contrary. And when I discussed casino, I discussed it in the sense that Mr. Seda allegedly invests less than 2 million with a number of other people, but he expects 255 million from this tribunal only, and then he expects everything else in Colombia as well because he has the other remedies. Now they say, oh, we can take an undertaking, but that undertaking will not resolve the problem of the multiple bites at the apple, and certainly not the problem of Colombia currently being the subject of a number of actions by the unit buyers against it. So that cannot be resolved. There was a point made by Mr. Moulou about the Colombian court and a decision on slide 6. This relates actually, and the only point I will make now is that when you read slide 6 of Mr. Moulou, it says, in a scenario such as this, of course, as usual, there's misrepresentation, and they don't tell you everything that follows is related to in a scenario such as this, which is asset forfeiture procedure. And Ms. Seda will explain to you why this is completely wrong and how you should indeed understand this, excerpt. Now, this was the first chunk of discussions by Mr. Moulou. Now, going to essential security, and there's a first point on essential security. So you have to go back, as usual, given the misrepresentations, to the actual record and what was discussed at the time a statement was made. And, of course, this has nothing to do with the point that I will now make. Reading for purpose of time, he refers to title studies. And as you know, by the way, that the title studies only look at the nominees. Now you know that, so it's not enough. And he says, he brags about having hired a regarded firm called Otero and Palacio, and now we know that Otero and Palacio did only a 10-year study, when we know that asset forfeiture proceedings do not have a statute of limitation. And then he says, I quote, they do a study that uses not only the list, like the Clinton list, and as people recognize, but they also use tools like Google. So he admits that Google can be a basis to do search, and hooked for any links, not only to people on the property list, but also to relatives, siblings, known husbands and wives. So any links that these people have are shown on any news. One thing you're commenting on is that these properties were passed from hand to hand with certain people. We did a thorough investigation. It doesn't show any of these things. And so what this shows is that he accepts that you have to do a thorough investigation. So he says he didn't know at the time, but even assuming in 2014 he didn't know about all of these people, which Ms. Herrera will show he knew or should have known before that. Let's assume in 2014 he hears from the journalist, well, the least he should have done then would have been to say, okay, maybe my investigation was not thorough, maybe I want to go back and do a double check, which he didn't do. If you see that, and actually that's the right order chronologically, so on 2 June, Mr. Seda volunteers to facilitate and pressure for a transaction between Ivan Lopez and the previous owners. You see that from a chain, and that you may remember this was also discussed in the May hearing, Exhibit 162, between Victor Mosquera, the lawyer, and Mr. Seda. And Mr. Seda says, this is something that has to be solved by the previous owners, whoever they may be, who sold the lot, but we can't do this, negotiate and facilitate the transaction and pressure from our end for the hassles they can cause. So essentially, Lopez Banega comes and says the land is mine, and then Mr. Seda says, well, read the actual text. I mean, it's not that difficult. Read the text. Nothing in this agreement shall be construed. So nothing in this agreement is a capture-all that says that nothing in this agreement, including investor-state arbitration, including standards of protection, including compensation, nothing in this agreement shall be construed to preclude a party from applying. Okay, so this is also what the U.S. says. I have to go back because Mr. Moulou does not respond to it. He doesn't have any response to it. I have to go back to the U.S.'s oral submission of 3 May, page 390, where they said, the claimant yesterday said that this allows a state to apply or continue to apply measures that it considers necessary for the protection of its own essential security interest, but that Article 22(2)b does not address the question of liability or compensation. The United States disagrees. This is their own state. The United States disagrees. Once the essential security interest exception is invoked, a tribunal may not thereafter find the relevant measures in breach of the Chapter 7 obligation and may not consequently order the payment of any compensation in connection with that measure. So this means what it means. Nothing in this agreement. It shall be construed to preclude a party from applying. This means that the party can apply. It can apply measures without any consequence, and there is no violation. By definition, there is no violation because this is an exception, an exclusion. The treaty doesn't apply, period. So you essentially are not even under the realm of the protection, the substantive protection, or ISDS, or compensation. Simply, the states can apply measures that they consider, and so on. So this is apply. So you have to interpret each word for what it is. So you can. So when Mr. Mulu says that it's an invocation of the exception, but which is fine, but it's not the dispute. I was not quite clear about what he says. I don't want to mischaracterize what he said, but what we say is very clear. Once this exception is raised, this tribunal or any tribunal does not have the power to make any determination of the exception. And by definition of the dispute, because the exception is raised in relation to a dispute. So this is, and he says, well, forget about self-judging. No, you cannot forget about self-judging. There's a footnote that is there. The footnote says, for greater certainty, once it's raised, the exception applies. The exception applies, and the treaty itself says the party from applying measure. So the exception means that the party can apply measures. Now, the self-judging is important because it says it considers. He doesn't address it considers at all. That's important. It's into your treaty. You have to give some meaning to it. It considers, right? Necessary for the protection of its own essential security interests. So now, they refer to Ecuador.
Sorry to interrupt just a second, but you're not saying, are you, that this means that as soon as the essential security exception is raised, there is no arbitral review possible of anything? Is that what you're saying?
The exception...
Including whether or not the exception is raised in good faith by hypothesis?
Well, again, and this was a mischaracterization by Mr. Mulu, who says, we accept that you can determine good faith. We do not. We have 3 layered scenarios. Our primary position is that this is not justiciable. Not justiciable is that you do not have the power to make a determination once the exception is invoked. This is what the US says, this is what Colombia says. You do not have the power to make any assessment, including whether this is in good faith or not. I'll come back to this because other treaties are worded differently. It's very important. So this treaty is worded in that sense. It says, it considers, and then it says in the footnote, for the avoidance of that, for greater certainty, once the panel shall find that the exception applies. Okay, so the exception applies. The exception applies means that the party can apply measures, right? So you cannot go beyond that. You cannot make any determination. That's the meaning of self-judging. If you're not with us on not justiciable, which is a power to adjudicate the matter, then it's you do not have jurisdiction because, again, of the self-judging wording, it considers necessary. You have to take for granted that when a state says these measures are necessary, they are necessary. And you cannot determine whether the exception is invoked in good faith or not, and you cannot determine the validity under the treaty of the actions. This is our second position. Our third position is in the event you do not find that it's self-judging, no power, no jurisdiction, in that event, third scenario, in the alternative, if you were to determine whether Colombia has raised it in good faith, then you should find comfort. This is everything I argued yesterday. You should find comfort that Colombia has raised it in good faith, timely. The essential security interests are fully at place, as you can see from the evidence on record and the factual circumstances that we're discussing. And therefore, you should give effect to this invocation of the exception, which is that no determination can be made of the validity of the measures, which is the measure that are in front of you under the dispute, which is that the Meritage was expropriated or Mrs. Seda was treated unfairly and so on. You cannot determine that because the provision says nothing in this agreement precludes a state from taking or applying measures.
So the provision means that the state is not only not precluded from applying the measures, but will escape any liability or responsibility under the treaty for the consequences of these measures, even if they are applied in a discriminatory matter, violate FET, you name it. That's your point, right?
My point, to be very precise, this is an exception to the applicability of the treaty. So the treaty does not apply, period. So since it doesn't apply, period, you do not even have to determine validity under international law and compliance with any obligations of the treaty because the treaty doesn't apply. It's over.
And what would be a circumstance in which the exception would be raised, assuming we go to your second option? What would be a set of facts under which a tribunal like this one should find that the exemption was not raised in good faith?
Well, that is if you do not find that it excludes your power to adjudicate,
Yeah,
a primary
assume
point,
that, yeah.
and your jurisdiction. So if you decide that you have jurisdiction to make an assessment as to the validity of the exception, then you determine whether the exception was raised in good faith.
Give me an example
If
of an
you-
exception not being raised in good faith in that context. What would that imply?
Well,
What would that entail?
I can't answer right now. I mean, it's factual. It's a factual circumstance.
Yeah, but I mean,
presumably.
wouldn't that be, for instance, a situation in which the admittedly essential interest of the state to fight organized crime, etc., would be invoked just as a way to escape liability for the consequences of what would otherwise be a violation of fair and equitable treatment? Is that a situation in which one could reasonably, again by hypothesis, find that the exception was not raised in good faith? In other words, if you raise it, but your real intent is to protect against something else, are you in good faith?
The point is really that you do not have the power or the jurisdiction to make that determination,
Going in
right?
circles.
No, I'm not going in
Yes.
circle. You
Yeah.
do not have simply. If you're in the circumstance where you want to determine whether the invocation is in good faith, you have to look at the facts. And the facts here are very clear. The facts are,
Let me just finish the second question so you can answer both. What do you make of that? And what do you make of the fact that after the 6 months period of the attachment, so to speak, or the English word escapes me, le séquestre, after that 6 months period, apparently we have an asset forfeiture proceeding that seems to be in limbo. What do you make of that? I mean,
so,
doesn't the, and again, it's a hypothesis, I'm not saying that this is the way it is, and I'm not saying that we are going one way or the other. Assuming we find that there is this investigation should not have remained in limbo as it apparently has, are we still in a situation where the invocation of the measure, the invocation of the exception, could be construed as being a good faith one that really stops the power of this tribunal to investigate anything and to adjudicate anything?
but if I may, Dr. Ponce, this is taking the order in reverse
Yes.
order, because you're looking at the validity under the treaty of an action, whether or not 6 months was enough or not enough. And Ms. Herrera will actually discuss the timing of the asset forfeiture proceeding. So whether or not the asset forfeiture proceeding and the way it unfolded was in compliance with the treaty is a matter which is different from essential security and our invocation in good faith of the essential security. The invocation in good faith of the essential security, which excludes the application of the treaty. So if you find, as you should, if you're in the third alternative, that this was invoked in good faith, you should not look at the substance of the case and whether or not asset forfeiture unfolded in this way or that way, because that's the actual merits.
Yes, but in order to find that it is invoked in good faith, don't we also have to find that the underlying asset forfeiture procedure has been conducted with sufficient due diligence? I confess to being somewhat perplexed
No,
by
sir.
the fact that, 6 years after this initial forfeiture, no charges have been brought, no decisions have been issued, nobody
No,
knows
sir.
what's going to happen to that land.
No, sir. These circumstances go to the application of the treaty to a set of facts on the merits of the dispute. Whether or not Mr. Seda and his acolytes were treated fairly. This is the substance of the dispute, the merits of the dispute, and you should not get there ever, we say. Even under our third alternative, which is that you determine that you have to assess and determine the good faith application and invocation of the essential security. Because if you do go there, which I hope you won't because you do not have jurisdiction, power and jurisdiction to do that, if you go there, you will have ample evidence in front of you to show that this is essential security. Colombia is doing this to protect its essential security, to protect, including the safeguarding of the of other countries than Colombia, because we're talking about the influence of the cartel even beyond Colombia. This is, if the fight against narco trafficking, killings, dangerous armed organizations, criminal organizations, and you see the U.S.'s reaction. The U.S. is talking about the UN Convention about fight against drug trafficking. There's cooperation, judicial cooperation and police cooperation between the two countries. How serious should we get for you to find that this is a serious essential security interest? So what we're saying is that once you find that, that's the end of the matter.
Hang on a second. Nobody is denying that it is an extremely important interest of the state. And I've had sufficient experience with Italy to, be plausible when I say that I have no doubt, okay? Because I know quite a few of the top Italian magistrates who risk their lives every month fighting the Ndrangheta, etc. So nobody is denying that. The question is, if we apply your scheme, there is really your scheme. If we apply your solution, there is really no room left for the hypothesis that Mr. Seda is a man in good faith, who acted in good faith. His only recourse is the local courts, which seem to be not particularly swift, put it this way.
That is not correct. I will start with the last part. That is not correct because the asset forfeiture proceeding has, and Ms. Herrera will address that with the timeline. There's an actual timeline that you need to see because to understand how it works. Mr. Seda himself, and she mentioned that yesterday, Mr. Seda himself has recognized that it does take time. Why? Because it's an investigation. Because this is a rule of law. This is a country that's governed by rule of law. They're not doing this just, out of their pocket. They actually go investigate. Investigation takes time. So they want to make sure that if the result is going to be a good faith third-party buyer. So that takes time. So, and she will address the actual timing. So that's completely different. And he does have the remedy. He has the remedy of the courts, first of all. He has the remedy of acting against the state, Article 90 of the Constitution. So there's no denial of justice anywhere. So this is the last part. Now, going to your previous question, you are bound by a treaty. You are duty-bound to give meaning and effect to this treaty. I didn't write this treaty. The U.S. and Colombia did, and they knew what they wrote. And I went through this yesterday, both in terms of the travaux préparatoires, what they said at the time, about what they said at this time. And so it says, nothing in this agreement shall be construed to preclude the party from applying measures. What does that mean? It means that the party can apply measures without any assessment, because it says nothing in this agreement. Otherwise, you would have had, and let me come back to other treaties, because other treaties don't say that. Because it doesn't say nothing in this treaty except the ISDS provision, except the compensation provision. It doesn't say that. It says nothing in this treaty. And it's not enough for Mr. Moulou to say, oh, I take another example, which is denial of benefits. Denial of benefits is a completely different animal. What you have in front of you is essential security, and you have to look at what it says. And what it says is nothing in this agreement, and itself, it considers, and I will come back to this if you allow me, because that has to be given meaning, what Colombia considers to be its essential security. That's why we say you do not have the power or the jurisdiction to judge, because the treaty has not given you the power or the jurisdiction to judge. This is what you have your arbitrators, and this is the integrity of the system we're talking about. Ms. Ordóñez explained to you, Colombia entered into these treaties with the understanding that arbitrators would uphold their intention and the consent that they have given and the limitations to that consent. And this is a limitation. This is a clause that says the treaty does not apply, period, when there's an essential security which Colombia or the US consider to be essential. Now, if you allow me, I do want, and this is exactly an answer to a question, if you allow me to go through some of my other points, because they will again, go to the language. Not at all. This is important, and I'm very happy for the questions, in fact. So let's take the Equoro. Mr. Moulou really likes Equoro, and I also encourage the tribunal to read Equoro. Please look at slide 13 of their rebuttal of this morning. In fact, Mr. President, you mentioned to Mr. Moulou a difference, but there's not only one difference, there's a number of differences. So, for the purpose of Chapter 8 investment, first difference, it's not nothing in this agreement, which is nothing in this agreement. It cannot be clearer than that. It says, for the purpose of Chapter 8 investment. Then it says, subject to the requirement that such measures are not applied in a manner that constitute arbitrary or unjustifiable discrimination. That means precisely what you're saying, Dr. Ponce. This provision allows a tribunal to make a determination as to whether the measures constitute arbitrary or unjustifiable discrimination. So this does give power to a tribunal to do just that and to make that determination. And if you continue, it says, nothing in this agreement shall be construed to prevent a party from adopting or enforcing measures necessary. It doesn't say it considers. You do not have that very important language. So you have three limitations here. It's only in relation to the investment chapter. It's subject to a determination by the tribunal about arbitrariness and unjustifiable discrimination. It doesn't have the it considers, so it's not self-judging. And the final point is that measures necessary to 3 limited grounds, including environment and animal and human life and so on. So it's not the broad exclusion that you have in 22.2b of the TPA that you have in front of you. So again, these are orange examples. It may be an essential security provision, but you have to interpret the language and you have to apply the language, ordinary meaning of the words. This is where you start. Now, they also refer to Nicaragua. I don't have it in my slides, but if you allow me, I will refer you back to Exhibit RL 152, which is the decision by the International Court of Justice.
It's in their slide 14.
In this slide 14. Yes, but they don't have the provision that you want to say, which is paragraph 222. In that case, the measures were about essentially the U.S. saying, Nicaragua is a risk to my security, and the measures were armed attacks, mining of ports, and so on. We're talking about the U.S. essentially doing all these things. So the court says that the court has jurisdiction to determine whether measures taken by one of the parties fall within such an exception is also clear a contrario from the fact that the text of Article 21 of the treaty does not employ the wording which was already to be found in Article 21 of the GATT. This provision of GATT, contemplating exceptions to the normal implementation of general agreement, stipulates that the agreement is not to be construed to prevent any contracting party from taking any action which it considers necessary for the protection of its essential security interests. In such fields as nuclear fission, arms, etc., The 1956 treaty, on the contrary, speaks simply of necessary measures, not of those considered by a party to be as such. So the ICJ makes the very clear distinction in an interpretation exercise between when you have necessary, which is what you have in Ecuador, and when you have measures that the state considers necessary. This is very different. And this, I think I also have somewhere, if I have not lost, I think it's also, I don't have it with me, but it's also the fact in the Russia case, and I have discussed that in May, in fact, so I don't have it with me. But it is the same logic that you have in the Russia GATT determination. RL 192 for the Russia decision. Now, I'm just looking at my notes to make sure that I've addressed everything. And also the time limit, there is, and as you see, Article 22(2) does not have any time limit. So it's important that when you're seized, at the time at which you're seized of the essential security invocation, you recognize that that has been invoked. And as we have said earlier, the moment when Colombia raised and invoked essential security is the moment when, based on... now, one final point. I want to make sure that I've addressed everything. Your question, and that is in answer to your question, Dr. Ponce, on the treaties. So if you, I will refer you back to our rejoinder of 16 February 2022. These are paragraphs 33 to and onwards, at the very least to 35. And you see in footnotes, there's a reference to a number of treaties entered into by Colombia. And you remember that this was, your question came up after I addressed yesterday the effet utile interpretation of treaties. And I said that you have to give, it has to be a purposeful interpretation, what the meaning that you give to this provision. And I referred, I think I may have misspoke, I said 17. In our count, I think this time I'm right, it is 15. Generally, it's 13 different treaties and the GATT and the Canada-Colombia FTA. These are treaties to which we refer, and you will see in paragraph 33 and 4, we explain that this provision that you have in front of you is exceptional, is quite unique. And that's why you have to give it the meaning that the parties said it should have, and that's why we said the authentic interpretation given by the US and Colombia is so important to you.
So it's not found in the others, right?
It's the
It's
others,
similar,
they are
but-
different. They all are essential security,
So this-
but they're different.
This
and
is
they,
a unique.
Yes.
This is a unique provision.
Yes, and we explain.
Why does the U.S. refer to the fact in one of the documents we saw? Why does the U.S. refer to the alleged existence of same provisions in treaties signed by the United States? So you're saying it's unique to Colombia, or are you saying it's unique, period?
It's unique to the treaties entered into by Colombia. I've not done the entire universe of essential security, and I do not want to speak for the U.S., of course, and since they listen, maybe they want to intervene on this. But we explain that these treaties mostly refer to measures necessary for the protection of the state's essential security, just as in Ecuador. They do not have the self-judging language of it considers, which, as you've seen in the Nicaragua case in the ICJ, said you have to make a distinction because one is not the other. It considers, we couldn't determine. This one, the 1956 treaty between Nicaragua and the US, does not have that. Therefore, we can make a determination. That's what the ICJ says. I want to finish, perhaps I really hope that I have said everything I wanted to say. I do want to take, before I pass it on to Ms. Herrera, I do want to take issue with no wrongdoing and maybe answer to one of your questions, Dr. Ponce. When we said there was no wrongdoing. This is in relation to the beginning of the asset forfeiture proceeding. Why? Because it looks at the asset. It doesn't look at Mrs. Seda. So you cannot say that Mrs. Seda is discriminated against because the asset forfeiture proceeding looks at the asset and just follows the trace of the asset. So Mrs. Seda, of course, he was not looked at for wrongdoing. I will stop here because, again, for lack of time, and Mr. Herrera will continue with the asset forfeiture and the discrimination and the merits. Thank you.
I appreciate that, Mr. President.
In the interest of time, please concentrate on what is really new, because we went through all this yesterday already.
Yes, Mr. President, just one thing. May I know how much time we have left?
5 minutes.
That's not generous.
Seriously? See, I take your word.
Out of the 49 minutes that you had, you only have 1 minute left, but,
No, but how come, I mean,
Yes, there was some.
oh, yes, and I was counting it. I counted 16 minutes of questions and answers. At some point,
I also asked for the indulgence of the tribunal because a number
Yes,
of my
yes,
comments were
yes. So you will have more than 1 minute,
Thank you. That's very generous. Magnanimous. Okay.
but can we say 10 minutes? Is that all right? Try your best, please.
I mean,
Well, yeah, we have at least 16.
No, the 16 minutes were deducted.
okay, I will go to the point.
This is actually important, so.
You have here the due diligence. I won't repeat about why the title studies are not sufficient, but I want to bring your attention to several points. If you see in point 10, a request made by Mr. Cintura, again, to the Fiscalia, asking, look at the list. We have discussed that Mr. Ivan Lopez could have been found and was there and all that, but I want to call your attention to the language that Mr. Cintura employs here, and he says, Corte Colombiana wants to verify, blah, 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 criminal nature against any of the following individuals that hold positions: managers, assistant managers, legal representatives, members of the board of directors, shareholders of the legal entities mentioned, blah, blah. And we're told, and that's something that Mr. Moulou said in May, it says, well, you know, it was only here, you don't have Mr. Ivan Lopez because this only look at as to the date of this petition, who were the legal representatives. And I would say this is very peculiar.
Yeah, but you said this yesterday already.
Yeah, no, but I'm saying this is peculiar. And I will submit, I will say you will have a much clearer picture of why is Mr. Cintura doing this. And we haven't been to present that that was an excluded evidence. Yeah.
As Ms. Herrera is looking for, I would like to draw the tribunal's attention to slide 20, which is a good summary of every point in time at which Mr. Seda, at the very least, should have sought for further due diligence, and he didn't. So you will have that to review in your own time.
On 18, same thing as Ms. Vanifitemi was saying, you have the points, and perhaps the one point that I want to make here is Ms. Vanifitemi have shown since one. So if I can refer you to page 60, and that has to do with the asset forfeiture proceeding, and you heard again the view that they weren't complied with, but you have the timeline of how they work. And again, I will limit my comments to specific points. You can see on 63 exactly the evidence that that Prosecutor Ardila had at any given time. I wanted to make a point about the point that my colleagues made this morning about Ms. Ardila having the information regarding the two title studies regarding the two, what they call the property and the sister property by the time she imposed the precautionary measures. And whilst it's true that Ms. Ardila said that, and I understand in the middle of a cross-examination, she might have said that, if you look, and this is C 024B, bis, that's, excuse me, I think I have it there. Don't I have there? Sorry, in the slides.
So you say C,
If you run, sorry, if you look in page, in the requerimiento, which is later on, is Mr. Caro, but you will see he's listing the sequence of information and when it was acquired. You have page 77.
Which slide are you on?
Sorry, page 77.
okay.
You will have seen, it says at point 60, when Ms. Ardila actually received the information from the criminal court in, excuse me, the Attorney General office in Medellin, sorry, the information she received, this information of the title, she received in March 27, 2017. So it was not, her memory may have failed her, it was not before the precautionary measures. And that goes to the whole argument of discrimination, which I will quickly.
I'm sorry, I didn't quite follow. I mean, did you refer to the allegation or what we discussed this morning, that she had at her disposal the two legal opinions before she issued the determination?
The
requerimento.
the measures.
The measures.
Preparation
Okay,
measures.
so are you saying that this is not correct?
That's not correct.
But
That was my response. It was incorrect. And when you look back at the
at what?
document of the requerimiento, which lists the order in which the prosecutors receive all the information, you will see when it was received in the record. So that was.
And could you point us to the document?
Yes, that's C 024Bs. That's part of the record in the part of the file of the asset forfeiture proceedings. And if you look now at the slide on,
C024?
correct, bis, and that's page SP 0118, and the specific paragraph is 60
In that document.
in that document. So, again, you have all the explanation. I will go back for as to the evaluation of good faith, etc. You have it there. One point,
C24Bs, on which page?
C
What page?
SP 0118.
At the bottom.
We're talking about C024Bs, right?
Correct.
On what page are you?
Ah, you mean on the presentation?
On the document, C024Bs.
At page SP 0118.
SP0,
118.
okay. That would have been simpler.
Sorry.
Can we perhaps put it on the screen?
Can you project it?
Yeah.
Okay. I hate to say this, but sorry. This was not in the hearing bundle, right? Because there it stops at 0151. I mean, I'm looking at C024 bis, and it stops at 0151, SP 0151.
Well,
You have 0118 before. 0118.
Microphone, please.
0118.
Yes, 0118.
118 en français.
Yes.
Okay.
I can't say it in Italian.
So I say C124 bis, 124 bis, right?
that right?
C024 bis,
Okay, oh, the
page
transcript is
SP
incorrect.
0118.
Okay, now we got it.
It's page 118 of the PDF. It's on the screen now.
Anyway,
Which paragraph on this page?
Where do we find the studies now?
60 is the paragraph 60 on the top. and they say dated, they received this.
Yes, but it does
But
not
that
indicate
doesn't-
the date, sorry, it does not indicate the date at which the study was received by the author of this document.
It says, we have the report, and this report contains the expansion of a complaint of Mr. Ivan Lopez Vanegas on February, and the study of the transfers of the Monroy, which is the Guzman Monroy, is the one relating to the, what they call the sister property.
Yes, but there's no date indicated at which they received this.
This is when the,
I mean,
I-
your point was that she received the documents only later and not, as she said, earlier.
Yeah.
But I don't see a date here that would confirm this.
I mean, the way I read it is in March 27, 2017, she receives further information which include this study.
Okay, we have the text here, and I
And-
think
and
we
you will
should go
decide.
further.
And just to confirm, this document is not authored by Ms. Ardila Polo. This is authored by Dr. Caro. She authored the determination of claim, not the requerimento. By this point, it's Caro.
Okay,
It says the document received in the file of the file of the asset forfeiture, so.
okay, so I think we covered that. Please, go.
I wanted, on this, again, the asset forfeiture and all the sequences, you have it there. One point that I wanted to address, and again, that's on the duration. I wanted to remind you of how extensive this investigation is. I already referred to that before. One point, and this is not, would come not as a surprise to the other party, is that as we have been informed that in fact Newport has asked for the nullity, annulment of all the process on the basis that they were not included as a affected party, which they were in the initial phase. That has been, there has been this is something that, if you're looking for it there, I don't have it. This have been told.
I'm sorry, we're not following. Could you repeat what you just said? I'm sorry.
We're still on your slide 77, or are you talking about something completely different?
Don't look at the slide.
So start again, please.
Okay, I'm going to refer to the duration of the procedure. So on the duration of the procedure, I wanted to remind you why it has taken so long. I already addressed that later. But I wanted also to update you on some developments that are known to our friends on the other side, which is the fact that Newport, after the decision of the court, the Superior Court, recognizing them. Exactly.
The 22 April 2022 decision.
Was rendered, and they were recognized as afectados in the trial phase. Newport asked for the annulment of all the process, saying that they have not been able to present evidence in the initial phase because they weren't considered afectados. But this annulment has been resolved. There has been, and now it's in appeal. So I'm just saying that because of the duration that it may take.
We have that request on the record. Don't remember it.
No, we don't.
And the decision?
And the decision don't. But, I mean, they know the other party.
Okay,
With
please.
with respect, you're testifying to something that's not in the record, right?
I'm updating. I'm going to move, given the time, basically to the arguments quickly on discrimination. And the submission of Colombia is that the claimants had not discharged a burden of proof the basis on which the asset forfeiture of the Meritage lot were started are several. And they are just focusing on saying, Ivan Lopez appeared. There was the transformation of the process, the physical and the legal transformation. If you look at the grounds, there are several grounds. They have not shown that any of the properties they are referring to are in similar circumstances. And again, they are also not showing why there's no justification to treat any of those properties differently, if there was. So that goes to like circumstances. I don't have the time to be more specific. That goes also to the sister property. There were many other, apart from the 25% not coming from illicit funds, and there were several other transformations that occurred in the Meritage lot that did not occur with the sister property. Now, as regards the standard of due diligence, I explained at length, and it cannot be denied, that the court was not referring, and that's very clear in the decision of the Constitutional Court, to the scenario we're referring, which is illicit, forfeiting assets of illicit origin. So now the claimants say, now, well, but, you have these two articles that allow you to go after some licit, excuse me.
You mean the paragraphs 10 and 11?
Correct, 1610 and 1611, to go after licit property. That's what they should have done. You may recall Dr. Reyes made very clear this, and that's at page 1219 of his presentation, of his cross-examination, when he responded to counsel for the claimant's question about this article, and say, for that to apply, for that situation to apply, so that you can actually have to go, so that the prosecutor has to go to a licit asset, because the property that should be first affected is in the hands of third parties, bona fide third parties. There has to be a determination by the courts that that property is in the hands of bona fide third parties. This has not happened here. I refer you to the transcript, day 4. And given the time, I don't think that I can make the other points. I don't know if Ms.
No. You done? So I would also encourage here the tribunal to look at slide 85, which is the final timeline, and the previous slides as well, of course, which explains the asset forfeiture timeline and timing, because there were some questions yesterday from the tribunal. We wanted to make sure that you have clarity about how the process goes on and what happened in this case, and what were the bases on which the prosecutors made the determinations that they made. Due to the lack of time, we will skip the damages slides, which you will have at the end, and on your own time you can have a look. We did respond to some of the points made by our colleagues on the other side. And one last point, if I may, is I want to clarify something that I said in response to your question, Dr. Ponce. Just I hope I was clear, but if I was not, whether or not the time was taken in the asset forfeiture proceedings, and the point I think that you made also in the May hearing, which is that this has taken a long time, that is the process of the asset forfeiture proceeding. The asset forfeiture proceeding was suspended for a number of years because of Mr. Seda's appeal about the afectado situation. So to the extent that they're using their rights to appeal the remedies that are allowed them under the asset forfeiture proceeding, and that creates delays, that's not Colombia's doing. Colombia has, again, a rule of law. They seize the opportunity to make appeals. If that appeal suspends or makes the process longer, that's their choice.
Well,
but Colombia cannot be faulted for that.
You, but the appeal was made in order to give him the chance to go to trial, because he needed to be recognized as an affected party, and so this took so long.
and they have been recognized now.
Yes,
So,
yes, but this was Mr. Poncet's point, 6 years after all
But-
this started.
Yes, and that goes to the merits of the dispute, which we say again, you don't get to because of the essential security, which is different matter. But on this, it will be for you to decide. Even if you were on this, you have to decide as to the whole, and the timeline is important, the entirety of the asset for future proceedings and the way that the investigations
Okay.
are going on those matters.
Thank you very much. I think we should give you the floor as to the point of the proceedings against Mr. Seda. I think this was the moment where you expressed the desire to say something. So be short.
Okay, Mr. President, I will, can I seek 5 minutes of indulgence?
Yes.
There are 3 points that I want to address, one of them being the one that you've just identified. I don't want to go on forever, but I think there's 3
Mr.
clarification
Mulu,
points.
I was clear. On that point, please.
Okay. On that specific point, the point that I wanted to make is that the record,
Yes, okay. Period. Sorry, but this hasn't come to an end. I think we should have a break now, also for the sake of David and his colleague. We should have a lunch break, because we need some time to, discuss how we see the further proceedings. And whether we still have questions. I mean, we put quite a few questions already, but we have to discuss whether we have further questions. So I would propose that we meet again at 1:45, giving us a little bit more than an hour. 2:45, sorry. 2:45.
In 5 minutes, I was wondering.
And perhaps in the meantime, if you could discuss among yourselves the further proceedings, meaning whether you still want to have some time to submit your cost submissions, whether you want to have the right to reply to the cost submissions, yes, these are the main issues left to be discussed, I think.
I just wanted to check with the hotel because we had canceled their lunches. So they don't have food. I mean, they could get the food, but it will take time. I'll go out.
Yeah,
An hour and, okay.
If you go out, then let's say we resume at 3, okay?
And then we could confirm with court interpreters and court reporters and interpreters. Yeah? Okay. I'll talk to the hotel.